The final matter to come before us this morning is Susan Miller versus Akron General Medical Center. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know. I'm keeping the clock this morning. I'll keep you apprised of the passage of time. The court's read the briefs and we're ready to proceed when you are.
Good morning, Your Honors. If you would reserve 5 minutes for me, please. May it please this honorable court. I am here on behalf of Susan Miller, who has filed this appeal after the trial court granted a motion for summary judgment. We feel the trial court lost its way in evaluating the facts and the law in this case. There was an original summary judgment which was overruled, filed on behalf of the appellee, which was overruled by Judge Brown. There was a motion for reconsideration by the appellee, that was overruled.
And counsel, before we go too far, I think I recognize you, but you are?
Robert Meeker, I'm sorry.
That's okay, thank you. That's all right, thank you.
Then a second motion for summary judgment was filed, and the court granted that, and the court seemed to have a difficult time understanding the test for an employer intentional tort as we deal with these concepts of intent to injure and substantially certain. The trial court got into definition and explanation talking about plans and schemes, which was analogous for me to a discussion of something that was involving conspiracy or premeditation, that concept where there had to be some plan ahead of time. And I don't believe that's the case at all in terms of the intent called for in this case. The fact pattern is important because we believe that the entire Akron General system broke down in this case, causing Susan Miller to be hurt. So if the court will bear with me, I'd like to spend some of my time explaining what happened. And I know you read it in the facts, but it's important to kind of put it together. Susan is acting as a sitter in emergency. A sitter is someone who sits outside of the psych rooms. That would, in this case, be room 33 and 34. And she's to sit there and observe the patients in those two rooms and make notes every 15 minutes as to anything she observed. So prior to Susan, to Terry Garko being brought in, a phone call comes to the EMS individual who is working as an employee, Officer Brooks, and the charge nurse, the nurse that's in charge of all the nurses, is right next to him. And she hears the yelling and screaming over the telephone, and she hears the fact that this patient is combative. She sees that written on Officer Brooks' sheet. So she swings into action, makes some immediate decisions. She goes right around the corner to where her psych nurses are. And she said, we're going to put this patient in 33. And she tells a triage psych nurse, Karen Weiland, to take the patient in 33 up to 6100, which is the psych ward. She said, we're going to use leathers, that means they're going to tie this person down, and they're not really made out of leather anymore. But she goes into the cabinet, gets the leathers, and sets them right on the table outside of 33. And she said, I'm going to get security and tell security to come here and put the leathers on. That's how their procedure worked. So she did go into security and made that arrangement. Now what happens is really important. The charge nurse doesn't stay in that area. She goes off to some other area of emergency to help another nurse. No doubt that she's working, I'm not complaining about that. But she's not there, and she doesn't put anybody else in charge. In the meantime, Karen Weiland, this triage psych nurse, takes the patient 33 upstairs, takes the security person with her, and she's up there 10 minutes or so. And Susan Miller is left alone for a minute. Now Tricia Troyak, who's the unit nurse and the triage nurse, is there. And now they bring in Terry Garko. Terry Garko had a long history, 20-year history, of coming to emergency with various psychiatric problems. She had been leathered down on at least 2 occasions. We give a detailed explanation of every one of her medical notes. Incidentally, the trial court had ruled in a motion in limine that the past medical history at Akron General was not admissible. We believe that was totally wrong, because Akron General had to know what they were looking at, what they were facing. And those records all should have come in so they could make a proper decision. At any rate, Terry Garko refused to cooperate with Nurse Troyak and a student nurse who was with her, so she wasn't able to do her preliminaries, and she wound up leaving the room. But she did do one additional thing. She got on the computer and she learned about the history of Terry Garko in Akron General Emergency. So now the hospital personnel that night knew what they were facing with Terry Garko. So now she goes off to take care of another patient, and here comes Terry Garko. She's put in room 33 by the people, the ambulance folks that bring her in there. And then Terry Garko proceeds, Susan Miller tells her to put a gown on. All she had is a big shirt on. She was told to put a gown on, and she then said, if the court will excuse the language, she said, "I hate you, I'm going to kill you, go fuck yourself," or used the F word on Susan Miller. Susan Miller was totally shocked by this. And she said, "I'm not putting any gown on." Susan Miller was able to give her a blanket in a little bit, but Terry Garko would not cooperate with her at all. So downstairs comes Karen Weiland now, and Susan Miller tells her, "We have a problem here." And I detail that in my brief, 4 or 5 comments that she made to her. That this is a tough girl, that she's supposed to be leathered down by security, but security never showed up. And she threatened my life. So Karen Weiland sits down next to Susan Miller outside in the hall and said, "Well, look here, I'm going to take care of the patient in 34 first. Then we'll worry about Terry Garko in 33. This was a huge mistake. So she sits down there, and now Terry Garko yells out, "I want some food." And Karen Weiland says to her, "You're not getting any food till you give us your vitals and you give us a urine sample." Right then, Terry Garko flies out of the room and attacks Susan Miller, who hadn't said boo to her at that point. She was just sitting at the table. She proceeds by grabbing her hair and her scalp, pulled a piece of her scalp out of her head, then takes her head with both hands and takes her knee and hits it into her knee 4 or 5 times. And she continued to pummel Susan Miller. Well, it took 3 people to get her off of Susan Miller. And finally they get her off of Susan Miller. Susan Miller has a variety of damages, which I won't go into with the court, unless the court's interested, but she was hurt badly, and the worst case of post-traumatic stress syndrome I've ever seen still results from her today. At any rate, we feel that the whole system broke down here. We believe that Kathy McConicle, by her action of going elsewhere, did an intentional act. And she should have been there on top of this problem. She could have had another nurse help the nurse who needed help. Karen Weiland clearly made a mistake. When she heard that that woman had threatened her and security didn't show up, and she was in charge of Susan Miller, who was just a tech. She was just a senior tech that had worked there for a number of years and loved working there. She should have, number one, got security immediately, closed that door or kept it closed until security came or some other male helper came that would have stopped that problem. And Karen Weiland totally failed and let down. Tricia Troyak, the nurse that had looked on the computer, once she found that this is someone who's been in here before many times, all the way back to '92, that she should have taken some action to say, wait a minute, I see the leathers sitting right outside the door, no one's putting them on this person, and now I've found this additional piece of information. At a minimum, she should have found Kathy McGonigal and said, look here, here's the history of this person. But she didn't do that.
At what point do we Where is it that the Akron General Medical Center is charged with the knowledge of Terry Garco's prior medical history or propensity to violence?
Prior to the attack, and when Tricia Troyak got on the computer.
So it's when one nurse looks at their records that are in-house.
She looked at the computer and discovered that, and she had just been in a month earlier with restraints put on her, just a month earlier. But she didn't tell anybody about that, Tricia Troyak.
Is there, I'm wondering if there's a dispute of fact regarding that, because I thought I read in the appellee's brief that when Troyak accessed the computer, that those computer records did not advise of the violent history or that she had been restrained, that information was not available to her from the computer that she accessed.
Your Honor, I'm standing here without that record in my hand, but I think the record would show contrary to that. I think Troyak learned a great deal about the history of Terry Garco by looking at computers, so we'll have to check the record on that. Thank you very much.
And counsel, you're reaching into your 5 minutes to rebuttal. You may continue or reserve.
I just want to say one thing if I can. Dating way back to the time when I was a prosecutor in 69 to 72, I learned the premise that a man is presumed to intend the natural and probable consequences of his actions. When all these people in this system went off in their direction, and you put that all together into one overall picture, by them failing to take the appropriate action, 4 different parties that I've identified, that provides proof. We don't have to show premeditation or a scheme or a plan ahead of time. They all had a job, they knew what to do, and 4 different parties didn't do it, and my client gets hurt so severely as a result of that. I'll reserve the rest of my time. Thank you.
May it please the court and respected counsel. We appear today to talk about an exception to a constitutional mandate, Article 2, Section 35, which states that the exclusive remedy for workplace injuries shall be the workers' compensation system.
And counsel, I probably know who you are, but could you identify yourself?
I was about to, Your Honor. I'm Dan Ballmert, and I represent Akron General Medical Center. With me today is Ms. Jessica Knott, who has also been involved in the case, and in-house counsel, Ms. Amanda Van Horn. When I say we're talking about an exception, this matter brings us before this court the exception. We are also looking at whether or not evidence has been produced by the plaintiff that would enable her to veil herself in the exception and collect benefits in addition to the workers' compensation benefits she has received. The exception to which I refer is the deliberate intent exception. As this court knows, back in roughly 1912, when the whole workers' compensation system came into being, a no-fault system, a system which did not look at the fault of the employer and did not look at the fault of the injured employee, but instead provided guaranteed swift benefits to the injured employee in the event of a workplace injury. There were originally two exceptions to the exclusive remedy of workers' comp. One early on was a common law exception, the dual capacity doctrine doesn't apply here. The second was a statutory exception, which said if an employer doesn't have coverage, then it is exposed not only to comp benefits, but also to common law claims without the benefit of any defenses, contributory negligence, assumption of risk, or fellow servant. Those were the two exceptions until 1982, when blankenship was decided. And in 1982, the Supreme Court discussed the concept of Restatement of Torts 8A. That's the section that deals with the substantial certainty form of intent. In 1984, the Jones case was decided by the Supreme Court, And that deliberate intent, or that substantial certainty exception to the exclusivity rule, was expanded. And it was further expanded in 1991, when the court decided both the Fife case and the Brady versus Safety Clean cases. It was after 1991 that the legislature decided that it was necessary to get back to the original compact, the original agreement struck between labor and management with respect to the exceptions to the workers' comp exclusive remedy. And they failed, the General Assembly, failed several times to pass statutes which passed constitutional muster. In 2005, however, they enacted Section 2745.1, which has now been determined and was determined by the Supreme Court in 2010 to be constitutional in the Kaminsky and the Stetter decisions. And so the test that we must apply and look to is whether or not there is proof in the record from which a reasonable juror might infer a deliberate intent on the part of Akron General Medical Center to harm Ms. Miller, or for that matter, someone else in Ms. Miller's position. I submit, Your Honors, there absolutely is not. 2745.01 requires a plaintiff seeking to avoid the limitations of the exclusive remedy rule to prove two things. First, a tortious act by the employer, not by a co-employee, by the employer. There has been a remarkable silence in this record and in the arguments this morning by Mr. Meeker of any involvement in any way, shape, or form by anyone in management at Akron General. What you heard and what was argued below was that the collective acts of some of Ms. Miller's co-workers resulted in her injuries. And while those acts, if we assume them to be true, might constitute negligence on their part, they do not arise to the level of deliberate intent. Your Honor, you asked a question about knowledge. I submit, Your Honor, that there is no evidence of any actual knowledge by any of Ms. Miller's co-workers, union sisters, the only other people identified in this case, except for paramedic Brooks, also a co-employee, or security guard Carson, also a co-employee. There is no evidence that any of them ever, first of all, the evidence is that they did not know Ms. Garko when she arrived, didn't recognize her. And the evidence is, as Judge Moore has indicated, no one saw her records. They saw an admission history. But there was no indication, and the deposition of Ms. Troyak clarifies this, there was no indication as to what she was admitted for or whether she had ever previously been restrained. And so there is no actual knowledge. But let's assume, just for purposes of argument, that indeed there was. Let's assume two things, neither of which I am prepared to concede. But one is that Nurse Weiland, or Nurse Troyak, or Nurse Bass, the co-employees, were somehow management, even though they are all union members, and that is part of the record as well. But let's assume that they're management. And let's assume further that they actually read the record and they determined that 2 months ago, not one, Ms. Garko had been in, and because of spitting, she had been restrained. That wouldn't change the outcome in this case for two reasons. Number one, the case law that we have cited in our brief, and specifically I would refer to the Kay decision, I would refer to the Barton decision, and I would refer to the Kane decision, make it clear that even if an employer has actual knowledge of a potentially dangerous situation, which was the case in many of the cases that we cited to you, the employer knew it was a dangerous situation. Courts have held in those cases that's insufficient to prove a deliberate intent by the employer to harm the individual. I'd like to walk through a couple of those cases just by way of example. The first case that I want to reference dealt with, the K case is an 8th District Court decision, Court of Appeals decision, 2009, decided under the prior Fife standard, which was the common law standard, the substantial certainty test, prior to the enactment of 2745. K involved a nursing home, but it's equally applicable here, whether we're talking about an emergency room, a nursing home, an urgent care center, a clinic, it doesn't really matter. In K, there was prior knowledge of the violent activities, the aggressive behavior of a resident. The resident had been previously restrained on occasion when necessary. In this case, at the time of the injury, he or she, and I don't recall, was not restrained. And the injury occurred, and the court held that is insufficient to prove or to establish a deliberate intent by the employer to harm the employee. The second case I'd ask the court to focus on is the Kane case. It's a little closer to home. It's not this court, but it's the Kane case against the Field Local School District. In that case, 11th District case, 2013, decided under 2745-01, the school district was aware of the violent, aggressive tendencies of certain disabled students that the employee was asked to work with, directed to work with. They knew of the aggressive behavior. They knew of the violent tendencies. They did not train the employee to deal with them, unlike Ms. Miller, who clearly, the record shows, had training on how to deal with disruptive patients, who had training on how to apply the restraints and seclusion policy, who was equipped with a vocera for instant communication in the event she needed help. The employee in Kane had none of those types of training, none of those types, not any of that equipment. She was injured by one of these students. Court held, 2013, insufficient evidence to prove deliberate intent. And finally, a case remarkably cited by Ms. Miller, the Abrams case. It's a court of claims case, interestingly, brought by a guard at a penal institution after he was assaulted by an inmate known to be violent, known to be aggressive. Court of claims holding insufficient evidence to prove deliberate intent. Where's he going with all this? The point is, first of all, none of the actors who were co-employees had knowledge. But even if they did have knowledge that Ms. Garko could at times be violent, that would not have, that would be a knowledge of a dangerous, potentially dangerous situation, but that's not enough to prove deliberate intent. Secondly, the other, I'm sorry.
Secondly, can you ever have deliberate intent on constructive knowledge alone?
No, Your Honor, you cannot. Moreover, there is, I'd ask the court to think about this whole concept of constructive knowledge in this setting. Constructive knowledge, if we adopt the argument Mr. Meeker puts forth, and every worker, every nurse, every tech, everyone in that emergency department is going to be deemed to know the content of every medical record of everyone who comes through that door constructively. I want us to think about the public policy ramifications of that. Because if we don't, and if, I'm sorry.
What if Ms. Garko had an infectious disease when she came through the door, and Akron General Medical Center's records revealed that this individual who's named this has an infectious disease? Do they have a protocol for that? I mean, that's the question when we're getting down to dangers coming into your facility and your workers.
Your Honor, the protocol would be that the patient would be brought in, he or she would be triaged, a history would be taken from the patient, and at the appropriate time, remember we're dealing with emergency medicine, I'm certain that when it's possible to do so, the records would probably be pulled to assist the medical providers in diagnosis and treatment. But precautions are taken, just as precautions were taken here to prevent against the eventuality of something like that. Let's assume, though, that the patient appears at the door, and 2 months prior, as in this case, that patient who's appearing for an infectious disease, a heart attack, some other emergency, had been restrained. Shall we preemptively restrain that patient simply because 2 months ago she was here and we had to restrain her? If we do that, we are going to expose every clinic, every hospital, every emergency room to claims of false imprisonment, to preemptively restrain, whether by leathers or by drugs or by seclusion. We can't do that. We will be exposed to incredible lawsuits. But if that's what we have to do in order to avoid an intentional tort claim because we have constructive knowledge of what happened 2 months ago, even though we didn't read the record, we're going to be forced to do that. And the policy that I was referring to, the public policy issues that overlay this, in my mind, deal with what the Hobson's choice that a provider is faced with when someone appears at his, her, or its door. In order to avoid liability in the form of a suit from a patient and a suit from an employee, the costs of medicine are going to go through the roof to deal with that. Or, worse, we're going to start closing those doors. Providers are not going to be willing to provide emergency medical services because of the exposure to liability, either from the patient or from the employee. The policy in place at Akron General Medical Center, a policy about which Ms. Miller complains that wasn't appropriately applied, is the restraints and seclusion policy. Patients who appear at our door have rights. We cannot simply preemptively restrain people. Mention was made of Nurse McGonigal. Nurse McGonigal, and let's put this in perspective.
And counsel, I regretfully need to inform you that you've reached the end of your allotted time for today. Thank you very much
Thank you, Your
for
Honor.
your presentation. Counsel, you have 3 minutes.
Okay, thank you very much. Judge Moore, back to your question. I refer you to the deposition of Nurse Troyak in the transcript, pages 16, 17, and 19. Even if it's true, is all she found out about the admissions, and she didn't find out any detail about them. Under the circumstances that we have a patient in there under these conditions that we've heard, she obviously could have gone the next step into the record and found what had happened. We're dealing with 4/15/11. She would have found out that on 3/9/11, Garko came in with his self-laceration of the arm with a razor blade, history of cutting, manic depressive disorder, and suicidal ideation. On 2/17, she came in agitated and was being held by 3 police officers and so forth, and on and on and on. And we have 20 years of that kind of behavior.
But we also have a hospital policy that disfavors, for obvious reasons, the use of restraints, and has some guidelines as to when the circumstances under which they can be imposed.
Well, Your Honor, when we get to the point that Sue Miller has her life threatened by this person after the earlier things that we knew before she got to the hospital, and Karen Weiland then decides to disregard that and sit down and work on another patient, obviously that was a time for the restraints to be put on and security to be called and something to have happened. But of course none of that happened, and so we wind up with my client hurt in the fashion that we did. I want to go back to the basic theory of how we get to the specific intent. I'd like to refer you to a case I just found last night. State versus Huffman, 131 Ohio State.
Counsel, we have a standing order that if it wasn't in your brief, we don't allow counsel to argue authority because the other side would not have a chance to respond.
Well, you heard me indicate, Your Honor, about my idea from being a prosecutor, and that's where that theory comes from, a 1936 Ohio State case, which I want to tell you.
And I'm not saying that we won't
Okay.
review those matters, it's just a matter of...
Okay, I think it would be important to do that. Thank you very much.
Thank you both for your presentation today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you again.